Welcome everybody. This is an update for Reform Utah Family Law, January 29th, 2015. And I wanted to share some things in my case without getting too personal about it, just to show how biased and how corrupt the system has gotten in Utah, and how the system has been basically drafted up and designed in a way to frustrate litigants from pursuing appeals after the fact when a judge makes a decision you don't agree with. There's certainly a number of major roadblocks in the way to frustrate your process in trying to appeal that, and I've been able to navigate them successfully so far, but they continue to throw them at me. And so I'd like to share with you today some of the things that have been going on in the case recently, and kind of give you an idea just how ridiculous and how far out of whack this system has gotten here. So let's just get right into that and get moving along here. So what I've done, because I do not want to confuse people, is I've gone ahead and I've designed a chart here, as you can see, to help as I explain this so that you can follow along with me and understand why I am making these claims of corruption and disregard for civil procedure and law by the courts. Now, this isn't just contained in the 3rd District Court, although there has been a lot of it there. I am now starting to experience that with the Court of Appeals as well. It's all state of Utah issues thus far. Nothing has gone federal. So everything that I'm going to talk about here will be on the state level. Again, that's not on the federal level. So let's just specifically talk about Utah and the state courts here. And I want to just get right into this and get moving to keep this as short as possible. So we're not going to explain the full history of my case. That's 17 years long. I could write a book, I could write 2 or 3 movies on it, and we don't have time. So let's start with the current issues and what I've done, and the reason that I'm basically making a complaint about it. All right, we start over here with the 3rd District Court. Okay, I filed an initial appeal to waive guardian ad litem fees in my case, and there's a number of reasons that I filed this. One of those being that there was never any legal necessity to have a guardian ad litem on my case. Okay, I've never been convicted of any type of crimes. In fact, I don't even have so much as a speeding ticket or parking ticket on my record at this point. So I've objected to having a guardian ad litem since the onset of this case. The respondent asked for the guardian ad litem as a way of basically strong-arming me and keeping me away from my child, which up till this point has been successful, but she's beginning to run out of avenues to use that, as I've filed multiple motions to excuse the guardian ad litem in the case, and also I'm getting ready to file some actions and ask for criminal investigation into some perjury he's committed, some fraud he's committed with the county recorder, and so she's running out of avenues for using the guardian ad litem. So anyway, getting back on track here, that's one of the reasons I filed to waive the fees. Another reason is that my income under the state and federal guidelines meets the qualifications. Okay, that's a personal thing. I'm not going to get into that. But at the time that I've asked for these to be waived, my income clearly qualified to have those fees waived. In fact, I've filed no less than 5 motions with the court over the last 2 years to waive those fees, and they've flat out been, my filings have flat out been ignored, or the judge has said he's not going to waive them. He is never giving any kind of ruling. When he gives that decision, he never gives any type of written ruling or any type of rules of procedure that he's followed to determine that. It's basically been a personal decision of his. And you can't, as far as Utah law explains and code is written, they cannot just decide that they want to impose fees on you. There's a certain procedure they need to follow according to state and federal law in order to charge you a specific amount of fees. And those fees can range anywhere from 100% all the way down to nothing, depending on your income. So that's one of the reasons as well that I filed an appeal to waive the guardian ad litem fees after the judge basically denied and ignored me on my motions to waive them for the past 2 years. And the other reason is he hasn't done his job. He flat out has not done his job, and he's committed fraud, like I said, and have all the documents and recorded evidence to prove that as well. But that's for another time. So that's the reason I filed. As you can see from my arrows, when I filed the appeal, it now goes from 3rd District Court. I filed it with the Supreme Court, okay? We'll come back to that in a minute. The next issue, I filed an appeal to recuse the judge in my case. Now, there was multiple reasons on that as well. The short of the story is this judge, quote unquote, has now been retired. I filed with reasoning of discrimination, bias. I had recorded evidence to back it up, and in fact, the Utah Judicial Conduct Committee not only notified me that they had assigned an investigator, but they were also going to conduct a formal investigation into the judge. It was about this time that I received this letter of notification from them that this judge officially, quote unquote, went on retirement. So I suspect, again, I have no way to confirm that because of the state's secretive process, but I highly suspect that my complaint, maybe with additional complaints in the past, were enough reasoning for this judge to finally decide there was some heat on him and he decided to personally retire. I don't know. But I do really believe that my filings and everything that I've done on it are a big part of the reason that the timing of his retirement and everything, it just coincides perfectly with all of my formal complaints with the right offices and with the state and United States Attorney General's offices as well. So those are the two actions we want to be talking about. If you follow those arrows over to the state Supreme Court, okay, this is going to be brief. Both of the issues were received and they were kicked back to the Court of Appeals. Now, this happens a lot with state law in Utah. It is fully acceptable. You can contest it. At this point, there was no reason for me to contest that, to be honest with you. So I didn't see an issue needing to contest this for them to kick it back to the Court of Appeals. I didn't have an issue with that. So now both of these issues, where we're at, they've been received by the Supreme Court in the state of Utah, both of my appeals, and they've now been kicked back to the Court of Appeals, okay? This is the current situation where we're at that I want to talk about. The Court of Appeals has sent me a letter, and I'm happy to share that with anybody that may not believe the validity of this. I'm happy to, in fact, I'm happy to even take a picture, white out some information on there, personal information, and post the letter on RUFL to share that with you. But basically, they've sent me a letter stating that my court fees were not paid to file these appeals. Now, you have two different fees. You have a $300 bond with the state of Utah, and you have a $225 filing fee, and that's in each case. So at this point, I would be talking about $1,100 in filing fees for my two appeals to appeal my case on issues that I believe I shouldn't have been forced to pay for in the first place. So there's one of the quagmires that we're talking about right there. Okay, now let's jump back to this and get right back into it. I had filed motions with the 3rd District Court initially when I filed my appeals to waive the filing fees. Now that means the filing fees of the $1,100 I just shared with you to file a case, 2 cases actually, with the Supreme Court in the state of Utah. I filed to waive those, right? Because if I don't have the money to pay the guardian ad litem fees, and I'm going to appeal having to pay those, I certainly am not going to have the money to pay $1,100 in filing fees with the Supreme Court. That makes sense, right? Hopefully everybody's with me. So I filed to waive those fees. And certainly the same laws apply for waiving those fees that also apply waiving the guardian ad litem fees in the first place. Basically, you submit everything to scrutiny under the court. You submit your income. You submit statements showing any properties you own, any type of possessions you own. Basically, they want to see what you have, and then they'll decide. Well, I submitted everything properly according to the guidelines that I find under the law. The fees should have been waived entirely for me. Well, the district court decided to reduce the fees to 10% on case 1. Now, this is where it gets important. Not only was I not notified that this had been reduced to 10%, which is typically the procedure followed by the court when you submit motions to the court on such items as waiving fees. They're supposed to issue you a written finding and also a written order on that. Now, keep in mind, I had filed a motion to recuse my judge in this case at that point, and it had been denied by his superior judge, who also sits on the same district court and bench with him. Conflict of interest there, but that's a whole nother issue. Now keep in mind, like I said, those filings were done with the 3rd District Court, and I had already filed a motion to recuse my judge and my formal complaints with the Attorney General's offices and with the Judicial Conduct Committee. And the judge that signed off and made the decision on this to reduce it to 10% was the same judge, in fact, that I had filed a motion to recuse on. Now, if that's not a conflict of interest to anybody out there, the next one really will be a conflict of interest. When you go to case 2, after researching it again, I never received a single correspondence from the court. Keep in mind, I'm not talking about the Court of Appeals. They've corresponded with me according to procedure, the way that they're supposed to. I'm talking about the 3rd District Court. They were supposed to make a finding of fact and issue an order on both of my separate motions to waive my fees on both of my appeals that were filed with the Supreme Court. Okay? Now, the second case, this is important. The second case, he decided to reduce them only 50%. Now, this is where it gets interesting. The second case, if you remember, was my appeal on my motion to recuse the judge in my case. The same judge that I filed that motion to recuse on, that should no longer have been signing documents in my case, now had raised it from me paying 10% on case 1 to 50% on case 2. There was no type of findings of fact issued to me, no type of order issued to me, and there was no logic behind him changing the amount of the fee on case 2 in any type of fashion whatsoever. And the reason that I can tell you that is the same fee waiver, meaning the same information on my income, was submitted from me on both cases because they were within a 2-week period, both appeals. So I had virtually identical paperwork, which means my income and all of my property and everything else was identical to the first filing. Yet the second filing, he decided to charge me 50%. Now, keep it in mind, that appeal was on my motion to recuse the judge that is now signing these orders for me to pay 50% and 10% respectively on the cases. Folks, if that does not show you the kind of conflict of interest that we have in our state courts, I don't know what does. Not only should this judge have stepped away once I filed these formal complaints and filed my motion to recuse, he should not have been signing anything on my case from that point forward, but specifically when I am appealing my motion to recuse him and there is a motion to waive the filing fees on that case, and that case is in regards to recusing that particular judge, it is his civil and procedural duty to recuse himself from signing off on that matter, regardless if I as a litigant have asked him to recuse himself from that. He absolutely should have recused himself on the signing of both of these fee waivers. And again, my appeal was in. I had motion to recuse this judge. I had filed all of my paperwork, and it's the same judge signing these that my motion to recuse is on. Now, keep in mind, that's one major part of it. The second part is I received absolutely no timeline or any type of orders. When I say timeline, I received no type of timeline notification from the 3rd District Court, meaning the judge that I have had all the issues with. Once I filed my appeals, they were supposed to make a decision on forwarding that appeal to the Supreme Court and send me a written decision. Now, I've called in, I've talked to multiple clerks, and I've asked why I have not received any type of paperwork in regards to these issues, why I did not receive any type of paperwork in regards to my motions to waive the fees. And what they've told me is, well, if you do not have a current address on court with the file, we can't send it to you. Well, I'm here to call out bullshit when it is bullshit, and this is bullshit. The same address, phone number, and information to reach me has been on my paperwork for the last 10 years. So that is absolute bullshit. They know it's bullshit. They know that it's an excuse for not forwarding me the paperwork. I believe that it was retaliatory from the judge because I had filed my motion to recuse him and he was now being retired. I'll just come right out and say it is what it is, and that's what it is. It was retaliatory. I had to contact the Court of Appeals on a daily process for a period of 2 weeks to make sure that I did not miss filing deadlines for things such as transcripts, docketing, your docketing statements, and things of nature that would very easily have my case kicked out of the Court of Appeals for not following procedure. So basically, the 3rd District Court again failed to follow procedure and law when it came to sending me their rulings and notifications as required. Okay, so we are up to, we're up to the point where everybody can kind of understand my complaints and see where I'm going with this. Now, here is the ultimate conflict and quagmire that I have. I am now running out of time with the Court of Appeals, and I either have to decide to pay the fees or I have to look at having my case dismissed. I have asked for a timeline extension of 30 days. I'm going to call for a hearing in the 3rd District Court to not only have them explain their findings like they are supposed to do as to why they came up with 10% and 50%, but also explain why the judge that was filed, when I filed to recuse him, why he was the one signing off on what I would pay in an appeal to recuse him. That's a big question that needs to be answered. And in fact, that is something that the Attorney General and lawmakers need to be looking at. So I'm hoping that this video is going to get in the right hands for people to see and understand the nature, the serious nature of the conflicts and the judges and the courts that we have out of control here that believe that they can do anything they want to without following civil rules of procedure and the Utah law. So that is where I'm at. I'm happy I could share that with you today. I'm sure there's other people with their own horror stories. This is just one small piece of the puzzle with me. I will keep you attuned as to developments on it. I don't know where it's going from here. Like I said, I've filed for an extension. We'll see how that goes. If not, and for whatever reason my case is bumped out of the Court of Appeals, it does not leave me a lot of options at this point other than to move forward with federal action against the state of Utah, and we'll be looking at a federal class action lawsuit with some other individuals involved, and move forward with federal action against the state of Utah for failing to follow rules of procedure, for failing to protect the parents under their own state statutes as they're required to do, and a whole host of other things that I don't want to give away if in fact it does come down to the fact that we will need to move forward with the federal lawsuit to gain compliance from the state of Utah. I hope that you found this to be informational. I know staring at a board for 20 minutes is boring as hell, but this information is super important to get out to the public. I plan on forwarding this to newspapers, news agencies, anybody that you may know that's interested in seeing this, that would like to contact me and talk to me about this. I'm happy to do that. And like I said, if anybody has questions about the documents in my case, PM me. I'm happy to talk to you about that. You can find me on Facebook under RUFL Utah. I'm happy to share most details. Some things are obviously personal, and I'm not going to get into super personal stuff. But I'm happy. My case is an open book. I'm happy to share it with people going through the struggle, and anything that I can share that may steer you from making mistakes that I have, I'm happy to do that. That's what I'm here for. My case, my child will age out of the system before this is resolved. I've got less than 2 years before she's of age. However, I'm not continuing this fight, the good fight, for myself. At this point, it is to change law here. It is to force the state into compliance with its own laws and with federal laws to protect parents. And I'm here because I have a hell of a lot of friends on here that have suffered, and people have committed suicide. People have gone and killed other people out of rage, out of anger, out of fear. And I'm not here to save everybody, but what I am here to do is to try and help as many people as possible and as I can avoid the hell that I've gone through, because it's been 17 years. And I've missed over 7 years of my daughter's life in that 17 years. And it is because of situations like this. You know, if I do not have the fees to pay for a guardian ad litem that I never asked for, and that according to Utah statute should have never been appointed to my case, and at this point should have been far removed according to statute, then you tell me how I am going to have the income and finances to pay Supreme Court or Court of Appeal filing fees in the amount of $1,100. They obviously know that, And they obviously do that, have this system set up in such a manner that there's no transparency and no accountability to any outside party other than the courts themselves. So in essence, if you go in front of a judge and he doesn't like you for whatever reason, he makes a ruling and says you're paying all the fees, and you might be living on the street, you're paying all the fees. Either that or you fight like I have. Well, it's time to change that. It's time to add transparency. It's time to add something to the law that gives clear, defined guidelines and statutes that these judges must follow when it comes to income, and not give them the discrepancy or the options to hold people hostage from their children because of finances. The bottom line, at the end of the day, it doesn't come down to finances that makes me a good parent. What makes me as a good parent is that I always look out for the best interest of my child, and I fight like hell, tooth and nail, to take care of my children and to protect them from these courts. That's what's made me a good parent. It doesn't come down to me being rich and being able to afford the top attorney in Salt Lake City to fight the court. So this has to change. I hope that this video is useful to some of you out there. There's certainly a lot more statutes and things that could have been explained, but it would have turned this into a 2-hour video staring at this board, so we're not doing that. Any questions, reach out to me. You find me online at RUFL Utah on Facebook. Happy to talk to you about anything that I can, and chat with you next time. Until then, be safe, bless all of you, and keep fighting the good fight, and let's get these things changed.